Derek DeBrosse, the gun lawyer.
Ohio gun lawyer here, Derek DeBrosse. Next question is with regards to brandishing a firearm. Question reads, we all know most gunfights end without a shot fired, and I know all states have their own laws, but if you're in a perceived confrontation, when would it be considered brandishing a firearm if you made it known to your assailant you are armed? It's really a self-defense issue. One thing I want to make clear in Ohio, there's no such crime known as brandishing a firearm. There's no such crime. Open carry is legal in Ohio. The potential violation you get into can be an array of different charges, all the way from aggravated menacing up to aggravated assault with a firearm specification. So just keep that in mind. I have recently defended both a misdemeanor aggravated menacing as well as a felony second degree aggravated assault for simply pulling the firearm. This gets into a really contentious issue amongst attorneys. Is the mere act of pulling the firearm considered use of deadly force? My position is that it is. Because if it's not, and you feel your life is being threatened and you pull that firearm and the other person was not armed, they can now feel their life was in danger and pull their own firearm and take your life because you've pulled a firearm. It's kind of a circular argument, if you will. So I think the mere act of pulling the firearm, you should never pull that firearm unless you absolutely intend to use it to eliminate a threat. With that being said, you can find yourself in a position where you feel threatened, you need to pull it, but then that threat ceases. It's called a cessation of the threat, and you don't use the firearm. You could be charged with a crime. I've defended people that have been charged with a crime in that scenario because the facts have not all come out at the time of the investigation. So keep that in mind. If you carry a firearm, I always tell my students, my clients, and my loved ones that you have to be ready to accept those consequences. There are other attorneys out there that say brandishing a firearm, as it's been stated in the question, could be a deterrent. But again, in any event, you're risking a charge by just simply pulling that gun. If you don't feel your life's in threatened, though, my opinion is do not pull that firearm to eliminate that threat. Can you announce that you have a firearm? Sure. Stop, I have a firearm, don't come any closer, that sort of thing. There's no need to pull the firearm unless you are ready and intend to use it because you feel that your life is absolutely in danger. But if you don't feel your life's in danger, it's not a time to use deadly force. I hope that answers your questions. I'm sure I'll have different opinions out there. It's not a black and white issue. Self-defense never is, never will be. It's been developed over hundreds of years from English common law, and it's something that it's very state-specific and a lot of times even county and local jurisdiction specific. Feel free to call me with any questions, drop an email to me, or drop a comment below. As always, be safe out there. Remember to carry on.